All right, y'all. I am just got home, and I am going to go over this bill. First off, I will tell you that yes, it passed the first vote tonight. And what do I mean? Tonight was a procedural vote in the Senate in order to try to rush this through without going through the typical steps of sending a bill to committee, etc. They're also playing a dirty game here, and we'll go over that a little bit here. Um, Let me know first off, audio, video, okay? Because I'm trying to be quiet because people are sleeping like right above me, and the last thing I want is a house full of angry people. Um, and I'm going to first start out by giving you the name of the 14 Republicans that voted for this bill. Also, the final vote will be Thursday. It's the way it's looking right now. The final vote on this will be Thursday. If they just continue to vote the way they did tonight, they have enough to invoke cloture and defeat the filibuster and get this through. Thank you for those who are saying it looks good, sounds good, awesome. All right, so on my social medias, I have just put up the name of the 14 Republicans that voted for this in the Senate tonight. They are Senator Blunt, Senator Burr, Capito, Cassidy, Collins, Cornyn, Ernst, Graham, McConnell, Murkowski, Portman, Romney, Tillis, and Young. So that's the 14 clowns who voted for this. I am going to share my screen here. We're going to go over the verbiage of the bill. Link is in the description. I'll put it in the pinned comment when I finish this. Damon, thank you, man. I appreciate you. Thank you so much. See if I can do a share the screen here without screwing things up. I don't do this enough here. Give me a moment to set it up. And this should be it here. And okay. So we got it here, and I'm going to rip through it kind of quick in some areas because some of the areas, look, I am never going to say that funding for mental health issues is bad. I think we should address that in this country, and we shouldn't have not addressed or brushed it aside as much as we have. Chet, thank you. Email Texas Republican Party. Yeah, well, they came out against Cornyn. I got a video that I'm probably going to drop if I can get to it tomorrow. But the Texas GOP came out against Cornyn and his leading this gun control thing, so that's a good thing. And they've also come up with some other good things out of their convention that I smiled at. So I'm going to go through some of this stuff. Like I was saying, that the mental health issues, I'm all for taking care of that, and beefing up school security, all for it. So my goal is there's 80 pages. It's not going to take that long to go through it, but this might be a little longer video. So if you don't want to watch it all, I understand. But please, right now, please thumbs up the video and start sharing it because we need this information to get out. I'm going to go through this and tell you exactly what it means, but more people need to see it, and they're not going to put this out. So please like it, share it, subscribe if you haven't already, and do all that stuff. So I've always told you guys and gals that if a bill has its own table of contents, it's usually not a good bill, right? And you see here we have a table of contents. Let me just restructure my screen here so I can see everything. The first part is the mental health for firearms provisions and the Title 1 of Children and Family Mental Health Services. There's not a lot in here that we need to go over. This is giving money for that so that we can increase funding and have ways to go about it. What this is a grant program. I can go up to a page here and I'll highlight. Hopefully you can see the highlight on your screen. Yeah, okay. So this is just setting up a grants for the mental health part. Sorry about that. And you can see it will beginning July 1st, 2024, and every 2 years thereafter, an additional 10 states can participate in the demonstration programs prescribed in the subsection. So they're allowing states to opt in as they go along. There's a couple dates changed in here. Like I said, none of this stuff is really crazily, excuse the pun, but like as far as what we're worried about, not terrible from what I was reading it. I did read this whole thing while I was at a baseball game. I didn't watch, like, I think I watched 2 innings of the baseball game because I was ripping through this. So, I have read it, a couple areas I've read a couple times, and we'll go over it together. I don't want to miss anybody. Lamont, thank you. I believe it is Todd Young. I'll have to double check at the list. I don't have it at the moment in front of me. I just changed pages. Are there any chances to stop this, Gene? Gary Gene, good question. The answer is technically yes, but probably no. So they had 14 Republicans vote for it. So the final tally, I don't have it in front of me. I think it was 64 or 67 votes. So you'd have to get some people to walk away and walk away quick. But yes, the only way that can happen is to put immense amounts of pressure on these senators, especially the ones who are looking for continuation of their job and their income. So again, this first part, if you want to read it in detail, I have the link in the description, but it goes over money and how they're going to be doing this through Medicaid and telehealth. You can see $40 million is for that part. The amount of money that you're going to see in this bill as we go through it is just astronomical. Where they're getting this money, they're just going to print it and put us into more of a recession. But I'm going to get to the pages where I think, if I were you, I would want to know what it was being tossed around. So this is all still healthcare and schools. Excuse the scrolling. Technical assistance centers, small and rural schools, and how they need to report stuff and the funding. So just an example here, the funding here, you got $8 million thrown here, you got $50 million thrown here, and these are chump change numbers for this bill here. School-based entities, secretaries, and stuff like that. The state implementations of early and periodic screening and diagnostic and treatment services. Now, I am going to say that maybe there's something in this that is not liked by some people. I don't know. I think that addressing the mental health issue can only be good because they shut this country down for 2 years and mental health has gone off the charts. And a lot of the programs that we used to have that would help people in times of crisis have gone by the wayside. But some more numbers here, 5 million there, another million here. Those are chump change numbers. We'll see a lot more. Let's get down to the guns part here. Mental health again and pediatrics. Let's use the scrolling. I just don't remember. There we go. Firearms. Title 2, Firearms. This is what we all want to see. Now, some of this wording is going to be bouncing back and forth. I'll try to make it as clear as possible. But this is going to be improving NICS examinations of juvenile records. So yes, AOC, they will be doing a look back into juvenile records for people who are aged 18, 19, and 20. And wait till you see the delays. So in the case of a person less than 21 years of age, in addition to all other requirements of this chapter, the system provides the licensee with a unique identification number. It also, this is the funny part, 3 business days, meaning a day on which state offices are open. 3 business days have elapsed since the licensee contacted the system, and the system has not notified the licensee that cause exists to further investigate a possibly disqualifying juvenile record under subsection D. So this is saying that they have a 3-day waiting period for these answers to come back. Can they come back sooner? Yes. Can they take longer? Yes. Let's keep watching. Keep reading. In the case of such a person with respect of whom the system notifies the licensee in accordance with Clause 2 that cause exists to further investigate a possibly disqualifying juvenile record, then 10 business days, meaning come on, highlighter. My computer is farting on me here. So 10 business days, which the state offices are open, have elapsed, and the system has not notified the licensee that transferring the firearm to the person would violate the subsection, or receipt of a firearm by another person would violate the subsection. So the 18, 19, and 20-year-olds purchasing firearms, 3 to 10 day business day waiting period. Business days, you gotta exclude holidays and exclude weekends. Keep that in mind. And shit, I don't want to overlook anybody. Curious to see if they turn that mental health flag against combat veterans. It's possible. Could anything in this be abused? Absolutely. Which is why I will say I do not support this bill. It's unneeded. There are other ways to address this stuff other than to smashing it together to get some Democrats to say yay and to get some Republicans to say yay on gun control. And I think we're all in the same boat. Next requirements, the Brady Handgun Violence Prevention Act is amended by adding the following. Requirements relating to background checks for persons under 21. If a licensee contacts the system established under section regarding a proposed transfer of a firearm to a person less than 21 years of age in accordance with subsection Tango of this 922 USC 18 USC 922, the system shall immediately contact the criminal history repository or juvenile justice information system as appropriate of the state in which the person resides for the purpose of determining whether the person has a possibly disqualifying juvenile record under subsection D. So if you're 18 to 20, they're going to look into your criminal history as a juvenile in the state that you reside. Now, guys, this is going to have a ton of problems because a lot of states, liberal states, Massachusetts, you really can't get access to that without court orders in some instances. This is going to be difficult for them to pull off, which is just going to keep people waiting, I would guess. That would be my guess. Also, B. Bravo, the appropriate state custodian of mental health adjudication records in the state in which the person resides to determine whether the person has possibly disqualifying juvenile records. C. Local law enforcement will be contacted. The agency of the jurisdiction in which the person resides for the purpose of determining whether the person is possibly disqualified juvenile record. And they need to do this as soon as possible, but in no case more than 3 business days after the licensee contacts the system. Notify the licensee whether the cause exists to further investigate possibly disqualifying juvenile record. If there is cause for further investigation, as soon as possible, but in no case more than 10 business days after the licensee contacts the system, notify the licensee whether or transfer the firearm the person would violate subsection D, meaning are they prohibited, or B, receipt of any firearm the person would violate subsection G or N of subsection 922 or state, local, or tribal law. So they're going to basically, long and the short of it, they're looking into juvenile records to see if this person will be disqualified, federally prohibited. And I've seen both arguments on that. I've seen the hell yeah, if they're that bad of a person and they're 17 or 16 or 15, then they should be held responsible. And I've also seen, hey, when we're all young and dumb, we make stupid mistakes and we don't hammer people when they're juveniles so that they can learn and grow up into be, normal, good, better members of society. So I'm not telling you how you should think on that, but I just think that there's two sides of the coin there. And that is going to be an issue for this as well. Sunset of requirements to contact state and local entities. Effective on September 30th of 2032, paragraphs 1B and 2 are repealed, and the provisions of law amended by those paragraphs are restored as if those paragraphs had not been enacted. Now, paragraphs 1, Bravo, and 2, if we go back up, all the way up, 1, Bravo, that's the 3 days. So they're going to get rid of the waiting period in 2032, unless there's a reason for them to keep this going. I don't trust them, but we'll see. Report on removing outdated, expired, or erroneous records. So there's a process there on how to remove that stuff if it comes up as erroneous, but you're going to have to prove yourself innocent before they even think that you're innocent. You're going to be guilty until proven innocent. Okay. Now, this part here, is this page 31? Yes, page 31. This is interesting. Defining engaged in the business. So this is going to have to do with people who sell firearms. If you bought a gun and you sold a gun and you made a profit, you're going to want to pay attention. If you are an FFL and have a YouTube channel and make money off of guns, this might be of interest to you as well. Defining engaged in business. So they want to amend 18 U.S.C. 921 by striking with principal objective of livelihood and profit and inserting to predominantly earn a profit. So somebody's going to figure out if you are doing this only to make a profit or if it's an objective of your livelihood. I mean, everybody's livelihood should be to make money and to make as much as you can to be successful at what you do, but not here in this government. This government wants to penalize you for that. This is the key part I want people to see here. Page 32, line 6. The term to predominantly earn a profit means that the intent underlying the sale or disposition of firearms is predominantly one of obtaining pecuniary gain, as opposed to other intents such as improving or liquidating a personal firearms collection. So if you're not improving or liquidating your personal firearms collection, what would that mean? Like, I'm going to trade a couple of these guns so I can get this one. Yeah, I'm going to make a profit on those, but I'm putting it towards this, or I'm selling everything off. They'll let you do that because it gets rid of the amount of things you have. But if if you have a gun and you're selling it to make a profit, and it's only to make a profit, this is going to be a problem. So provided that proof of the profit shall not be required as to a person who engages in the regular and repetitive purchase and disposition of firearms for criminal purposes or terrorism. So if you're a naughty person, you can't do that. For purposes of this paragraph, the term terrorism means activity directed against United States persons, which A, is committed by the individual who is not a national or permanent resident alien of the United States, and B, involves violent acts or acts dangerous to human life, which would be a criminal violation if committed within the jurisdiction of the U.S. C is intended to intimidate or coerce the civilian population, or to influence the policy of government by intimidation or coercion, or to affect the conduct of a government by assassination or kidnapping. Now, here is another problem we're going to have to talk about here. The BYRNE, burn grants for implementation of state crisis intervention programs. Red flags. This is the red flag situation. So bear with me on this one. There's a lot of words, but I think they need to be said because, again, this is an area, don't need it. Don't need it at all. It's a violation of our Constitution. It's a violation of our civil rights. It's a violation of everything we have in this country as far as how we operate, how we were created, as far as rules and regulations prohibiting government from doing stuff. Here we go. So this is they're making money. This is the bribe the state stuff with these grants. The implementation of state crisis intervention court proceedings and related programs or initiatives included but not limited to mental health courts, drug courts, veteran courts, and extreme risk protection order programs, which must include, at a minimum, 1, deprivation and post-deprivation due process rights that prevent any violation or infringement of the Constitution of the United States, including but not limited to the Bill of Rights and the substantive or procedural due process rights guaranteed under the 5th and 14th Amendments to the Constitution of the United States, as applied to these states, and as interpreted by the state courts and United States courts, including the Supreme Court of the United States. Now, what does that mean? It's a lot of verbiage, right? They're saying that in order for a state to get this money for their red flags, one of the holdups for this bill was A, abortion, so that no federal money could be used for abortion, and 2, how they were going to divvy up this. I got to sneeze, fighting it. How they're going to divvy up this money for the states who might not want to have a red flag. So they came to an agreement that each state would get divvied up the money equally amongst the states. I saw cat litter. That's a cool name. Thank you. Yeah. Oh, wait till you see the definition we have down in the boyfriend loophole area. So, in order to get this money, your red flag can't have a violation of due process. So as I read it, and I am not an attorney, but I do read bills and laws enough to know that there is not, to the best of my knowledge, I have read all 19 red flag laws in this country, but it's been a while and I don't remember them word for word. But I don't think any of them um, don't violate your constitutional rights. So this would preclude those. This would be like the Achilles heel of the red flag, I would think, the way it's written. But let's continue, because there's a lot to it. Such programs must include, at the appropriate phase to prevent any violation of constitutional rights, at minimum, notice, the right to an in-person hearing, an unbiased adjudicator, the right to no opposing evidence, the right to present evidence, and the right to confront adverse witnesses. 2. The right to be represented by counsel at no expense to the government. Time the fuck out. That's saying that you have a right to an attorney on your dime. So we're still going to allow states to go after you, this pre-thought crime, to think that you're dangerous because somebody said so. And if you want an attorney, you got to pay for it yourself. We're trying to take away your rights and your property on the whim. But if you want to defend yourself, spend all your money to do it. That's a problem. That's a big problem. 3. Pre-deprivation and post-deprivation heightened evidentiary standards and proof, which mean not less than the protections afforded to the similarly situated litigant in federal court or promulgated by the state's evidentiary body, and sufficient to ensure the full protections of the Constitution of the United States, including but not limited to the Bill of Rights and the substantive and procedural due process rights guaranteed under the 5th and 14th Amendments of the Constitution of the United States, as applied to the states, as interpreted by the state courts, the United States courts, including the United States Supreme Court. The heightened evidentiary standards and proof under such programs must, at all appropriate phases, to prevent any violation of any constitutional right, at minimum, prevent reliance upon evidence that is unsworn or unaffirmed, irrelevant, based on inadmissible hearsay, unreliable, vague, speculative, and lacking a foundation, and penalties for abuse of the program. So this is saying that you can't take the whim of another, like every state that has a red flag now, like, little Ray Ray's babysitter said that they came over and you had a gun there and you're a naughty person. They can't use hearsay anymore. And there need to be fines associated with abuse. Now that's going forward. That has nothing to do with the 19 states that are already on the books. So in order for another state to get a red flag qualified for this free money, they got to meet these. And from what I just read to you, it won't be a red flag if they meet this stuff. So maybe a little gamesmanship here with the Democrats and Republicans. This is not as bad as it was first being talked about, but this is not needed anyway because this is still a violation of our rights. So F them. And then they're going to do an annual report on these programs, an annual report to the Attorney General, description of the grants and all that stuff. We don't need to know all that. Stop Illegal Trafficking in Firearms Act. Now, it's been illegal to traffic firearms for a very long time. And also anti-straw purchasing in firearms trafficking amendments. It's illegal to straw purchase firearms. But it gets worse. Straw purchasing of firearms definitions. For purposes of this section, the term drug trafficking crime has the meaning given in the term 924C, section 2, and B includes a felony punishable under the law of the state for which the conduct constituting an offense would constitute a felony punishable under the Controlled Substances Act. 2, the term federal crime of terrorism has a meaning given the term in section 2332B Bravo G George 5, and the term felony The term felony means any offense under federal or state law punishable by imprisonment for a term exceeding a year. So if it's a drug crime or if it's anything punishable by a year in prison. And this is where people can get caught up too, because the term felony means any offense under federal or state law punishable by imprisonment for a term exceeding a year. There are states, Massachusetts, who have super misdemeanors with a term, the technical punishment, the sentence for it, exceeds a year or 2 years. And those are considered felonies, even though they're misdemeanors. They're considered felonies by the federal government, making you prohibited federally. Case in point, Massachusetts, the operating under the influence, OUI. It's a 2.5-year super misdemeanor. If you have been convicted of it in Massachusetts, you are federally prohibited. You can get your rights back on appeal to the Firearms Record Bureau, but the federal government considers you prohibited federally. Okay, violation shall be unlawful for any person to knowingly purchase or conspire to purchase any firearm in or otherwise affecting interstate or foreign commerce for, on behalf of, or the request or demand of any person knowing or having reasonable cause to believe that such person, A, or 1, meets the criteria of one or more paragraphs of 922D, means they're prohibited federally. 2, intends to use, carry, possess, or sell or otherwise dispose of a firearm in furtherance of a felony, a federal crime or terrorism, or drug trafficking crime, meaning they're going to use this in that crime. 3, intends to sell or otherwise dispose of the firearm to a person described in paragraph 1, a prohibited person, and a penalty in general, except as provided in paragraph 2. Any person who violates subsection B shall be fined under this title, imprisoned for not more than 15 years or both. If you use a firearm in a felony or a crime of terrorism or drug trafficking, then if a violation of subsection B is committed knowing with a reasonable cause to believe the firearm will be involved in using what I just said, the sentence will be no more than 25 years. So, trafficking in firearms in general shall be unlawful for any person to ship, transport, transfer, cause to be transported, or otherwise dispose of any firearm to another person in or otherwise affecting interstate or foreign commerce, and if such person knows or has reasonable cause to believe that the use, carrying, or possession of a firearm by the recipient would constitute a felony, meaning this person is, you can't transport, ship, transfer to a federally prohibited person. Or received by another person any firearm in or otherwise affecting interstate or foreign commerce, if the recipient knows or has reasonable cause to believe that such recipient would constitute a felony. Sorry, guys, I'm beat. Or attempt to conspire to commit that. So this is already illegal. 15 years plus a fine, plus forfeiture. Civil there's some civil forfeiture that they threw in here. Any person convicted of these violations shall forfeit to the United States, irrespective of any provision of state law, any property constituting or derived from any proceeds the person obtained directly or indirectly as a result of such violation. They're going to take anything they can tie to that firearm: your car, your house, your computers, your money, anything. B, any of the person's property used or intended to be used in any manner or part to facilitate the commission of such violation, except for the fact that forfeiture of any firearm or ammunition pursuant to this section shall apply. So, government stealing people's stuff, basically. The Racketeering Amendment, which is 18 U.S.C. 1961, is amended by inserting related to straw purchasing, so they're going to put that into racketeering, and trafficking as well is going to go into the racketeering amendments. Money laundering, they'll be put in there as well. Directive to Sentencing Commission, we don't give a damn about that. Technical conforming amendments. All right, just go blah, blah, blah. It's all the same crap. If you have smuggling guns and all that stuff, all this stuff is already illegal, but we need to put it in there again. I'm sure there's a reason that we're going to find out. Prohibition of firearms or ammunition transfers to agents of drug cartels. I'm wondering if Fast and Furious will be here. I wonder if the ATF is watching. Well, I know they're watching, but I wonder if they're going to get caught up in this. I doubt it. FFL's access to law enforcement information. So this is for voluntary background checks. In general, no later than 90 days after the date of enactment of this paragraph, the Attorney General shall promulgate regulations allowing licensees to use the National Instant Criminal Background Check system established under this section for purposes of voluntarily conducting an employment background check relating to a current or prospective employee. The Attorney General may not collect a fee. Okay, so if somebody's going to work for a gun shop, you got to make sure that they're not federally prohibited. And this would include if you were to hire the 18, 19, and 20-year-olds. This is going to apply to them as well. There's another section here. There's 80 pages. We're on 50. I told you it wouldn't go that long. Although we're 29 minutes into this, so I apologize. I'm trying to go as fast as possible. Local law enforcement reimbursement for assistance provided to the Department of Homeland Security to prevent illegal trafficking. This is all still has to do with trafficking. All right, here's the boyfriend loophole. And after this is just money. They're going to talk about money. All right, misdemeanor crime of domestic violence. Misdemeanor is the key. All right, you don't lose your rights in this country for misdemeanors. You just don't. But they're going to try to lump a whole bunch of people into this created loophole that they're creating. And it is potentially very, very dangerous and, in my opinion, unneeded here. So, define dating relationship. They want to. This is the one that's already on the books that I told you about the other day, 921A of the USC. They want to strike or by a person and insert by a person. They should have just struck or, but this is how government works. By inserting before the period at the end the following, or by a person who has current or recent former dating relationship with the victim. So if you're currently dating or former dating had recently broken up, then this is a dating relationship. And they also want to add the following. The term dating relationship means a relationship between individuals who have or have recently had a continuing serious relationship of a romantic or intimate nature. Whether a relationship constitutes a dating relationship under subparagraph A shall be determined based on the consideration of the following. 1, the length of the relationship. 2, the nature of the relationship. And 3, the frequency and type of interaction between the individuals involved in the relationship. C, a casual acquaintanceship or ordinary fraternization in a business or social context does not constitute a dating relationship under subparagraph A. There is no retroactive application. Okay, so that doesn't mean that if this passes, then you're going to get all kinds of complaints lodged against you. This is no retroactive application here. It shall not apply to any conviction of a misdemeanor crime of domestic violence entered before the date of enactment of this act. Why? Double jeopardy. It would open the government up to getting sued on some of this stuff, which they should be getting sued shortly, I would imagine. Limitations on convictions of crimes of domestic violence with respect to dating relationships. Now, this is going to get convoluted, but try to stay with me here. They want to add the following. A person shall not be considered to have been convicted of a misdemeanor crime of domestic violence against an individual in a dating relationship for purposes of this chapter if the conviction has been expunged, meaning if a court has deleted it and it didn't happen, or set aside, or is an offense for which the person has been pardoned, or has had firearm rights restored unless the expungement, pardon, or restoration of rights expressly provides that the person may not ship, transport, possess, or receive firearms. So if you had a charge removed in a multitude of different ways, you're not considered to have been convicted of this misdemeanor unless the judge still says you can't have your gun rights. So you could have it expunged and pardoned, but if they still say no gun rights for you, then you have been, for the purposes of this boyfriend loophole, you have been convicted of a misdemeanor of domestic violence. You're going to be federally prohibited. Provided that in the case of a person who has not more than one conviction of a misdemeanor crime of domestic violence against an individual in a dating relationship and not otherwise prohibited under this chapter, the person shall not be disqualified from shipping, transporting, possessing, receipt, or purchase of a firearm under this chapter if 5 years have elapsed from the latter of the judgment of conviction or the completion of the sentence, custodial sentence, or supervisory sentence. So if you have been convicted, then you can get your rights back if 5 years have been elapsed since you were either judged or got out of prison or jail or off your supervised sentence. And if any, and the person has not subsequently been convicted of another such offense, a misdemeanor under federal, state, tribal law, or local law, which has as an element the use or attempted use of physical force, or the threatened use of deadly weapons, or other offenses that would disqualify the person under Section 922G. The National Instant Criminal Background Check System, established under 103 of the Brady Handgun Violence Prevention Act, shall be updated to reflect the status of the person. Restoration under this subparagraph is not available for a current or former spouse, parent, or guardian of the victim, a person with whom the victim shares a child in common, a person who is cohabitating with or has cohabitated with the victim as a spouse, parent, or guardian, or person similarly situated to a spouse, parent, guardian of the victim. All right. So you're not going to be able to have your rights restored if any of that applies. Why is my trackpad dying on me here? Let me see. My mouse will be better. No, must just be the program. All right, other matters. This is Medicare stuff. This is the School Safety Act. We'll go through that real quick. Blah, 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 blah. School Safety Act, evidentiary, blah, blah, blah. So I want to rip through that. I didn't really read this part much in detail when I was at the game. Paperwork Reduction Act, clearinghouse contents. All right. The clearinghouse is going to be proven ways to keep schools safer. Yeah, criteria for evidence-based practices and recommendations. That would be the clearinghouse. Shall include a comprehensive evidence-based school safety measures, include the evidence or research rationale supporting a determination of the clearinghouse that the evidence-based practices or recommendation under subparagraph A has been shown to have significant effect on improving health, safety, and welfare of persons in school settings, including relevant research and the evidence, blah, 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 blah. So this is saying that this is going to help schools be safer, give them funding, and tell them practices which work. By the way, have you all seen what happened in Uvalde? The beginning of the investigation came out today. Wow. Those cops. Wow. All right. So the rest of this is notification for the clearinghouse. This still has to do with the school safety stuff. The grant program, how to get money to them, and funding on the Elementary and Secondary School Act. This one here I wanted to show you. All right. Department of Justice, Federal Bureau of Investigation, salaries and expenses. Why is this even here? Well, let's find out. For an additional amount of salaries and expenses, $100 million to remain available until expended to meet additional resources needed by the National Instant Criminal Background Check System. So the FBI is going to get more money to run more people through NICS. State and local law enforcement activities for assistance in doing this. Some states do their own checks and stuff like that, but they're going to throw money. For an additional amount of state and local law enforcement assistance, $1.4 billion to remain available until expended for grants to be administered by the Office of Justice Programs, provided that $280 million of it to remain available until expended shall be made available for fiscal year 2022. $280 million to remain available until 2023, $280 million to be available until 24, $280 until 25, $280 until 26, provided that the funds made available under this heading of this act used for the following purposes. $750 million should be awarded pursuant to formula allocation. Dude, there's a tons of millions. $200 million should be used for grants administered by the Bureau of Justice Assistance for purposes of Stop School Violence Act. So the rest of this is just money. Yeah, there's like I said earlier, it's a ton of money, and this is it's over $20 billion if I remember right. But this is called the Bipartisan Safer Communities Supplemental Appropriations Act. Let me get this off my screen because it pisses me off. So there you guys have it. Half an hour, 40 minutes I did it in. It's 80 pages. I know this is a long video. Hopefully some of y'all are still here and will do what I need you to do, and that's to share this video. I need you to like the video. I need you to share it. I need to make sure you're helping the channel get the word out, because this is going to get stomped on left and right. Again, 14 Republicans voted for it tonight. In the procedural vote in the Senate, the final vote is going to be Thursday. Why is it going to be Thursday? Because they don't vote on Friday and they're gone for 2 weeks. The Senate is on break. They want to rush this through. And I told you they're playing dirty politics. They're going to strip a bill that it's Senate Bill 2938, I believe. It's been a while. It's been a long day. But it's a bill that was already dead, but it passed the House. It didn't pass the Senate. So they're going to strip out the wording, put the stuff in it so that it'll pass the Senate. It's already passed the House. Technically, it's just an amended bill. The House can just say, yup, done, and it'll go to the president. So it's dirty politics. That's what they're doing, strip and insert. And guys, thank you for your time. I appreciate each and every one of you. I'm looking through. It looks like I missed some of y'all with super chats and stuff. I apologize. Jeremy, thank you, man. Also, I'm going to try to do another video. Not tonight. I'm done. I'm spent. Thank you, Ryan. But there's some more states that are picking up where Biden has failed as far as another body armor bill, another body armor ban bill, and some more magazine bans. Don't forget the Washington State one starts July 1st. Man, I'm beat. So that's right around the corner. But that's it, guys. Be safe, stay vigilant, carry a gun to keep you, your friends, your family, your community safe. Let your friends know about this video. Make sure everybody sees it so they know exactly what is in this, because it was going to be worse. It's still bullshit. We don't need it. But that way they know exactly what's in the bill. So when they start calling their senators, they're going to have the right ammunition on what to say. All right. I hope you all enjoyed this. I hope you all got something out of it. So now you saw the bill. You know what it means. The bill is in the description. Share it, please, and subscribe to the channel. Help me get to that 500,000. We're that close. Like that close. Thank y'all. I need to go to bed. Take care.